our old wonderful Supreme Court has made a decision about how they're going to play out this idea of equity and diversity within the Chicago Fire Department. And Lori, I want to kind of let you bring us into focus on that.
Well, I think it's an excellent ruling. I think they've finally gotten it right. A lot of times
Were you surprised like I was?
I was very surprised. I know a lot of times we've talked about the fact that you can't let technicalities get in the way of justice, and in this case they finally made a firm decision to make sure that that doesn't happen. And in this case, they're now addressing the issue that we've talked about on the show before, where the African American firefighters were protesting a test that they took, an application test that they took, where a lot of them, they felt it was discriminatory because a lot of them were ruled out. And basically the facts of that was that if you make under 64, you're automatically disqualified, but if you made it over 64, you're supposed to be qualified. Chicago then made a additional cutoff point of 89, I think it was, where they said you're highly qualified as opposed to just qualified, and the people that made over 89 only constituted about 11% of the black applicants. So since they were planning on only exhausting the highly qualified before they went into the people who fell between the 64 and the 89, a lot of black applicants did not get jobs. And it's interesting because with these decisions, there's usually the argument that they put forth that, oh, well, this highly qualified is the issue and we think that this is more applicable. But they actually dropped that argument after a while and made the argument the timing factor as to when the African American firefighters filed for that. Normally you have 300 days in which time after the decision to file for it. And I think they filed a little over 400 days.
Right.
So they were trying to get it thrown out. But the Supreme Court has made the decision that it doesn't make sense because,
And Anton Scalia.
Yeah, that was a shock.
Anton Scalia, who's been pro everything except black people, actually wrote the chief decision on that, and I was very surprised.
Yeah, he basically said that, first of all, the argument that they were able to bring in is the fact that Chicago continued to use the process of that test result to hire people. They were saying basically you're starting a new clock each time you use that same test. So you can't say that the cutoff period that was after those 300 days.
It was a new act of discrimination occurring every time they used that list against those people that scored underneath 89.
Yes.
And I think the problem with the issue was that 89 was a point that they set, and they didn't tell anybody. Arbitrary thing that they set, which forced people to believe that the test was biased in the first place. So they're going to go back to the whole issue of Richard Daley, who's real popular with us, with the Burge case and him being the prosecuting attorney for the city and allowing the statute of limitations on that particular issue to expire before he prosecuted some of those Chicago police officers.
The Supreme Court probably had some stronger legs to stand on in terms of overturning the firefighters case, only because I think when you examine the situation, that second cutoff date had no basis in fact.
Right.
I mean, they had no reason to. It didn't prove that those people were more qualified to do the job, and that's specifically what we have government agencies to fight discrimination over. There are certain circumstances where employers can defend it, where they say, okay, if physical strength is necessary, then we can discriminate against hiring a man versus a woman, things of that nature. But I think because they had those two issues, they had the one issue of whether or not that second cutoff really made those people who passed over the 89 more qualified or not to do the job, and they have the situation of the arbitrary cutoff.